just hearing about the latest amendments, but some interesting tidbits as well. As the plan for the evening is, we'll have Neha Gada, who's the president of the Chamber of Tax Consultants, and Kinjalbhai Shah, who's the president of the Bombay Chartered Accountants Society, briefly introducing both these organizations, which are, of course, very committed to spreading of knowledge, not just amongst their members, but amongst the public at large. We'll then have Aditya Pradhan introduce our speaker for the evening, and then we'll hand over to Ramesh sir. So Neha, all yours. Thank you.
Yes.
Yeah.
Good evening, all, and thank you for such an overwhelming response. Before taking much of your time, we will briefly.
Neha, you're not audible. I
Organization
think
and it's
yeah.
is it
Still,
Apurva Bhai?
still
Sorry.
buffering a bit. Yeah.
Okay, so it's a 100-year-old organization, and we founded on the timeless principle of Gnanam Param Balam, where knowledge is the supreme strength, and the vision of CTC is very clear: to promote education and spread knowledge. Welcome all to the into legal wars and complications into the societies from no other than Ramesh Prabhu sir. Thank you, Apurva Bhai.
Hi.
Yeah, hi, good evening, everybody. Friends, as we start with this session, I think the first record is held by Bombay, where the first cooperative housing society was formally incorporated, which is called the Saraswat Cooperative Housing Society in Gamdevi, Mumbai. And that was the first cooperative society of Asia. And I think today, when we assemble here, there's a pride in the concept that cooperative comes from cooperation of all, and it is for the all, it is managed by the all. Friends, it's going to be an interesting topic because I would say that this is a topic which touches every common man of every city and town where you live in a cooperative society, or you may be part of the agriculture cooperative credit society. And that is where this topic holds a relevance amongst not only the professionals, but also amongst large uh, spectrum of common citizens of India, and specifically Maharashtra. Friends, coming to Bombay Chartered Accountants Society, it is the oldest and the largest voluntary body of chartered accountants, established in 1949, and has more than 12,500 members across 400 towns and cities of India. The core objective of the society is to spread knowledge and upskill its members and help the society at large in dissemination of knowledge. Friends, I wish you a very happy learning and welcome you all to this very interactive session with Ramesh Ji Prabhu. And over to you, Apurva Bhai. Thank you.
Aditya, you could introduce Ramesh ji.
Sure. Thank you so much. Thank you, Apurva bhai. Ramesh Prabhu sir is a chartered accountant and also a CISA qualified professional. He is a widely recognized and a very respected voice in the field of RERA, real estate, redevelopment, cooperative societies, non-profit organizations. Ramesh sir has authored around 40 books on housing society management and 4 books on RERA. He has contributed as an editor, speaker, faculty, member, knowledge leader for various professional bodies, institutions, government departments. He has also been associated with committees and consultation regarding to the Deemed Conveyance Law, Maharashtra Cooperative Housing Societies Act, rules, election rules, model, bylaws, RERA related forms, reforms, etc. So with this, I would hand it over to Ramesh Prabhu sir. But before that, I will request all the participants that in case if there are any questions, to put it on the chat box. During Ramesh Prabhu sir's lecture, we will not be taking any questions. Once his lecture is done, we will be taking the questions. So we request you put all your questions in the chat box and we will take them after his session. So with this, I will hand it over to Ramesh Prabhu sir. Thank you so much.
Thank you, C. Aditya Pradhan. At the outset, let me thank Bombay Chartered Accountants Society as well as Chamber of Tax Consultants for giving me this august opportunity to share my thoughts and views, especially on the law in which I was a part of the committee in the framing of the act as well as the rules. There is a privilege that I am having, and based on some of the inputs, maybe I'm also part of the bylaws which is going to be done. So thank you, CA Neha Gada, the president of Chamber of Tax Consultants. Congratulations to you for arranging this public seminars jointly with, of course, CA Kinjal Shah, president of the Bombay Chartered Accountants Society. Yes, we have been discussing with the professionals, colleagues, but when it comes to the public like webinar, this is the first time that you have both have taken initiative. I really compliment. Yes, CA Kaushik Javeri has been a close friend of mine and who has given me an idea that these are the two bodies who are spreading knowledge would like to come together, and he has coordinated along with CA Apurva Shah. Really, thank you very much for giving me this opportunity. With this, I'll just share with you how I want to design my complete 1.5 hour session. Maybe 10 to 15 minutes we'll devote for the question answer as we move ahead. But basically, I will be dealing with the Maharashtra Co-operative Societies Act, which is the latest amendment which has happened. And following that, there is rules which was published on 18th of June 2026, as late as a month or 2 months back. So how this act and rules are coordinated, so that I will deal with it. And then there are lot 5 to 6 years, lot of judgments have taken place, because assuming that a lot of professionals are going to be taking part and they need in-depth study. So I have covered some of the case laws relating to that act and rules. So with this background, so the presentation is going to be a little exhaustive, but what I will do is I'll take the gist of the PPT. I'll not go through the reading the PPT. I have made a PPT exhaustive around 134 pages, but given the time constraint, what I will do is I will highlight the provisions and then straight away go to the rules and of course the judgments. That's how I will be doing. With this, let me just share the PPT so that everybody will be able to and come on the same page. I hope you are able to see the PPT.
Yes.
Yeah.
Yes,
So this is an webinar, as we said, the Chamber of Tax Consultants, which formed in the year 1926, and Bombay Chartered Accountants Society, which formed in the year 1949, have come together and have thought of doing this programs, webinar, on the latest amendment and recent updates on the Maharashtra Co-operative Societies Act 1960 and the rules 1961. So as I said, we are going to restrict our discussion on the registration and management of co-operating society, for which a special chapter has been incorporated with effect from 9th March 2019 in the MCAs Act, and the rules have been framed after about 7 years, effective from 18th June 2026. So therefore, let me straight away take you to the Act. In the MCAs Act, we have nearly 14 chapters. So chapter number 1 talks about preliminary, that is what is the Act and the applicable definitions and where it is applicable. Chapter 2 talks about registration. Third talks about members, their rights, liabilities. Chapter 4 talks about incorporation duties, privilege. 5 talks about state aid to societies. Property funds, that is 6th chapter. 7th is management of societies. 8th is audit, enquiry, inspection. 9th is settlement of disputes. 10th is liquidation. And 10A is insured cooperative bank. 11 is Cooperative Agriculture Rural Multipurpose Development Bank. 12 is Offences and Penalties. 13 is Appeals Revision. And 13A is Multi-State Cooperative Council. And the last is miscellaneous. In between the last provision, miscellaneous provision, a new law or the new chapter has been inserted effective from 9th March 2019. That is chapter 13B, which is related to the management of cooperative housing society. And therefore, my focus is going to be on the management of housing societies. Now, what is this 13B all about? So section 13B has been inserted specially to consider the special features of housing society. What happens is in Maharashtra, we have nearly 58 types of cooperative society registered. If there are 58 types of society, 57 is one side and the other one, housing societies, are on the other side. We have around 225,000 cooperative societies, 225,000 cooperative societies in Maharashtra, out of which 125,000 is housing societies. And nearly 1 lakh are other type of societies. Now, what is the main distinction if we have to talk about housing society and other type of society? One, housing society, number of societies are more than 50%. Now it is reaching 55%, 60% of across 225,000 society, 125,000, which means more than 50%. Second, the housing society is the one where members are owning the part of the capital or the asset of the society, and it is more connected with the immovable property. And it is a non-profit. There is no profit element of whatsoever, neither it is doing any business. But when you talk about other type of society, whether it is a sugar cooperatives, cooperative bank, urban credit societies, consumer society, sugar factories, agriculture society, wherever you see, all these are doing business. And there it has nothing to do with the property. The member has two activities. One, he invests in the capital, that the shares he can ask for the refund, and whenever he wants after 1 year. Second is he can do the business, either supplying the produce, let us say to sugar cooperatives, or if it's a consumer society, he can buy the product. If it is a cooperative bank, he can deposit and earn the interest, and on the other side, other members can borrow the money and pay the interest. So this way, they are all connected with the business. When it comes to housing society, where he is going to live, where he is having his day-to-day activities, and there are various bundle of rights. As we go ahead, we will know. So therefore, the housing society required a special treatment. And though the law was in the year 1960, and as Kinjal Shah has rightly pointed out in the beginning, Saraswat Cooperative Housing Society was registered in the year 1915. So it is about 116 years back. Now, 111 years back. Now, that building is still standing. Now, that society, that is Saraswat Cooperative Society, was registered in the year 1915 under Cooperative Society Act 1912, which was a central act. But then in the year 1960, Maharashtra Co-operative Society Act was enacted. So even if you take 1960 till today, that is of 2019, nearly about 70 years later on, the new law, or rather a new chapter, was introduced considering the special feature of housing society. Therefore, it has been given a special treatment. Now, when this law was made, basically, it is divided into, chapter 13B, and it has got 32 sections. Which are the 32 sections which are specially related to housing society management and registration? The first is section 154B, and thereafter 154B1 to 154B31. This way, 154B is the first section, and then 154B-1 to 154B32, 31. Like this, there are 32 sections. And all these sections, as we are going to discuss, you will know it starts with the definition. Then it starts with the, the membership, registration of the society, rights of the members, how the committees are getting elected, then how the shares are getting inherited, transferred, and then various related to the management of the housing society, how the general body will be done, how the membership will be, application will be made, how the transfers will take place, and the recovery of dues will take place. So many things are being discussed. So we'll go one by one. Now to start with section 154B, here there are two subsections. Subsection 1 is talking about the sections which are going to apply out of nearly 165 sections, out of which are the sections that is going to apply mutus mutandis to housing society. That has been listed in subsection 1, and subsection 2, these sections which are not applicable, the chapters which are not applicable. So this way, the section 154B, the preliminary section, talks about the applicability and non-applicability of the various sections in the MCL. So this, what happens is, one will be able to concentrate for a management of housing society sections which are applicable. So that out of the 165 sections, hardly 100 sections must be applicable. Rest of the sections, like insured cooperative bank, like in cooperative credit societies, cooperative bank, what is not applicable can be easily eliminated, and it becomes much easier. Now let me take you the rules. So now I'm coming to the rules. As I said, my entire lectures is going to be act, rules, and judgment. So now comes MCS rules 1961. So where chapter 13B has been added. Earlier, what was added is 13B in the act, and in the rules, chapter 11B has been added. So separate chapter for the rules have been given. This has been inserted on 18th June 2026. Now 106 is the just before the preliminary section, last section. So in this preliminary chapter, miscellaneous chapter in the rules also. So just before that it has been done. So rule number 106C-1, it says which are the rules not applicable to the management of housing society. What do you mean by rules? Rules, we know, rules means normally it's a procedural aspect. However, provisions of the act are getting implemented by the registrar or the stakeholders, especially housing society committee and the members, how that will be implemented. So section 1, rule number 106C-1, non-application of provisions of these rules to housing society. Which are the rules not applicable? It has been given in the Gazette itself. That rule number 4, 19, sub-rule 1 of rule 20, 22, 25, 27, 38, 35 to 48, 49B, 49C, 53, 53C, 63A, 66, 86A, and rules 93 to 103 are not applicable. Which means when you pick up the rule book, you can simply cross these rules so that you don't have to concentrate on that, and it becomes easier for you to apply, understand, and then proceed. Now let me take you to the sections again. Now there are 154B1 is the first section. There are about 20, 25 definitions. I'm not going to deal with each of those definitions. What I've done is the most important definitions I have picked up. The first definition, which we have to read, is nothing but the allotee. Allotee, the reason being given allotee is the same definition used in RERA. As you know, Real Estate Regulation and Development Act 2016 came into effect from 1st May 2017. So there the word definition of allottee has been given. Allottee means the person who is buying an apartment or a plot or a building in a real estate project, or whom the apartments are allotted, resold, all that. So even the reseller is considered as an allottee. And considering that definition, the MCS Act, in the separate chapter, we have included in subsection 1 of section 154B1. Here, the allottee means, the word is, allottee means a member of a housing society. Why it is a member of a housing society? Because we are talking about housing society. So therefore, member of a housing society. Then, to whom a plot of land or a site, that means some of the places the word site is used, especially in Karnataka. So therefore, in RERA also it has been used. So whom a plot of land or a site, that is plot, or a flat in a building, in a multi-story building, a building, or in a complex. If there are complex where there are what you call villas or bungalows, so it's a gated community. So then complex has to be owned by society, held by it. That means either held on the freehold basis or leasehold basis by a society. So that means, very important, in Maharashtra, a housing society is registered when a plot of land or a building or both are owned by a housing society. So that means who is the owner of the land, or who is owning getting the land on lease basis? Society. Then the members will be able to get an allotment of the plot as a lease basis, then a flat in a building on occupancy basis or membership basis, ownership basis, or in a complex where bungalows can be owned. So therefore, it is said is allotted by a cooperating society. So what can happen? Housing society can come together, construct a building or bungalows, or make a various plots in a layout, and then they can give an allotment to a member. Or second, allottee is also a person who has purchased an apartment or a flat from a developer or a builder or a promoter, as they say in the RERA, or from a competent authority. Now you may say, why competent authority? Competent authority means MADA can also allot a flat, CIDCO can allot a flat, municipal corporation can allot a flat. So therefore, when these flats are allotted on an ownership basis to these allottees, then they can join a cooperative housing society as a member. So therefore, allottee basically means a member in a housing society who has got a plot, or who has a bungalow or a villa or an apartment, or which is also called flat in a multi-story building, or it can be through purchase. This is a very important definition for me. Second is, what do you mean by flat? The definition of the flat very nicely has been picked up from RERA. So whatever the definition of apartment is given in RERA, same thing has been picked up here, and a lot of resemble is there related to RERA. Why? Because Real Estate Regulation and Development Act also is talking about, in a multi-story building, a housing complex where various apartments are given, sold by the promoter. So means a block, chamber, dwelling unit, apartment, office, showroom. What is missing here? Let me just point out, is garage. Earlier, if you see the bylaws, or under the MOFA definition, a closed garage was considered as an apartment or a flat, and the separate membership used to be given. But now there is a judgment of the Bombay High Court also recently, wherein it has been said that now the housing society definition under 154B 13, the word flat does not include the garage, and therefore a separate membership was rejected. So just to give you any self-contained units in a industrial premises, residential premises, commercial premises, godown, all these are called as a flat. Any other type of use ancillary to the purpose specified. What do you mean by purpose specified? Where it is specified? Naturally, it is specified in the approved plan. These are all things which are available in the approved plan. So whatever is defined in the approved plan, they are considered flat. I'll give you some examples so we'll understand. There are some places where they call it as a servant room, a separate independent servant room. I have also seen some places where they have multi-purpose unit. What do you mean by multi-purpose unit? It could be a single room with multi-purpose means one kitchen platform is given, and it is more like a studio apartment, and then there is a washroom or toilet, and this way it's one room with multi-purpose where one can sleep, kitchen, all that is available. So therefore, even that, those being a self-contained, are considered as an apartment. There can be an apartment like a chawl type. What do you mean by chawl type? There can be 100, 150 square feet each, small one room kitchen flats, where the common amenities like the toilet, washroom is given outside. Still they are called as a self-contained unit. And there can be industrial, there can be offices, there can be shops and offices. All these can be considered as self-contained units, are considered apartment. Now you may ask, Mr. Prabhu, why you are discussing so much about these two aspects? This entire foundation is based on that. Because the number of members in a housing society cannot exceed number of flats in that building. Very important. Number of share certificate to be issued is equivalent to the number of flats in the society, and therefore one has to look into. Now, the other important, again, the sharing of revenues, as we come to later, that is about sharing of expenses, again to be divided service charge equally among the number of apartments or the flats. Now, from where you get this? This you will get from the approved plan. Now, I'll give you an example. Now, somebody may be having 2 flats and he buys 2 apartments, flats nearby, Jodi flats, and they combine. Now, housing societies in that case will have to issue 2 share certificates to the same person, and they will be charged 2 maintenance in spite of they having club, unless until the approved plan gets amended. So therefore, this is very important for you and me to understand this. Now let us go to the next. Housing society. What do you mean by housing society? Housing society, because ultimately we are talking about a housing society. So therefore means the objective of which is, there are 4 objectives which are given. Now if you see the earlier definition in the old act before 9th March 2019, the 3rd and 4th definition was not there. Absolutely not there. There were only 1st and 2 definition. Now 3rd and 4th definition has been added in the definition of housing society. This is very important. The reason being that based on this, the jurisdiction comes into picture. So the objectives of the society is very important to understand where a dispute can be filed, because ultimately the jurisdiction in the court is based on the objectives of the society. So therefore, to provide its member with the open plots for housing, dwelling units, dwelling houses, that means bungalows or villas or row houses, or flats in a multi-story building which has already been defined, or if open plot, dwelling houses or flats are already acquired. It is also possible that people may acquire their open plot, they may acquire dwelling houses, they may acquire the flats in a multi-story building, and then they form a society. That is possible. Once society allots, therefore I said allotment. Second, after you acquire from the developers, you form an associate allottee as a housing society. Second, to provide its members common amenities and services. Now, what are the common amenities? Naturally, garden, parking, road, lift, all this, common staircase and common electricity. All this comes, drainage facilities. So to provide its members common amenities and services, firefighting systems, common security systems. Then comes to demolish existing. This is the third and fourth is added, because as you know, from 2000 onwards, year 2000 onwards, we have seen redevelopment happening in Mumbai and across Maharashtra from say 2018 onwards. So initial 18 years, we have seen a lot of redevelopment happening in Mumbai in a housing society. And in 2018 onwards, because in 2020, the Unified Development Control and Promotion Regulation 2020 has come in. Because of that, the TDR, auxiliary FSI, additional FSI, incentive FSI are enabled across Maharashtra. And therefore, lot of boosting in the redevelopment, especially MMR region, Mumbai metropolitan region, Pune, Nashik, Nagpur has started happening. And therefore, the housing society was not having the objectives of redevelopment earlier. Now, when the law was amended in the year 2019, the committee thought it fit that we should input this so that any dispute related to the redevelopment can go to cooperative court. Otherwise, Bombay High Court had given number of judgments where they said that because the objectives of the society does not include redevelopment, the dispute related to the redevelopment should go to civil court or commercial court, and therefore a lot of botheration used to happen. Now what happens? Any dispute related to the redevelopment between the member and the society now can be taken to the cooperative court, and because you are the primary person is the society, you can make a necessary party as a builder also and take them to the cooperative court. And now this has been possible because of these two additions done in the objectives or the definition of housing society. That is to provide its member common amenities and services, that is over, to demolish the existing building and reconstruct the building. So the reconstruction is possible when there are no additional FSI is possible, then they come up for reconstruction. And second is to reconstruct additional tenements, additional FSI and premises by using potential of the land. Because of the Development Control and Promotion Regulation 2034 of Maharashtra, Mumbai, and Unified DCPR of 2020 of Maharashtra, now redevelopment is possible. Additional units can be constructed, and those are also considered. Redevelopment is now considered as objectives of the society. Now, let me take you to the case laws. I defined under the Act, then let us talk about case laws. Section 1, subsection 17 and 154B, section 31, which is a saving clause. Last section is a saving clause, which says that whatever has been done earlier is still applicable even though the new amendments have come. So in the case of Piramal H. Solanki versus Bhumik Common Society Limited and versus others, interim application of 2022 decided by a Bombay High Court on 6th October 2020, it says that although the amended definition of housing society includes demolition of reconstruction and redevelopment, existing bylaws do not automatically change. This is very important for you to understand, because in 2026 only the rules have come. Now, once the rules have come, the new bylaws are going to come. Based on the rules and the act, bylaws were not amended earlier. Now the bylaws will be amended. Once the bylaw gets amended, saying that the objectives of the society is also going to be redevelopment, then this case laws of the Bombay High Court becomes redundant. This says that because the housing society bylaws which is adopted by the society does not have the redevelopment as an objective, and therefore unless until the bylaws is amended, a dispute cannot be considered as a dispute concerning the business of the society, and therefore that dispute cannot go under section 91. But now, henceforward, certainly once the bylaws are amended, which will be amended, where of course I am a part of it, I will be certainly seeing that the objectives what is given in the housing society will be covered in the objectives in the bylaws also, and thereafter one can go to cooperative court. And therefore one has to be very careful. Henceforward, once the bylaws are adopted, the dispute related to the member and the housing society related to the allotment of the flat, additional area to be given, corpus to be given, you can now take it to the cooperative court, even if the procedures are not properly followed. Now let me take you to the next definition. Very important. And this is a landmark, insertion in the Act. Types of apex societies. Earlier, there was only one definition, which is talking about housing federation. Now, there are two more additional definitions have been added, and two more types of societies have been included. One is 154B, 1 subsection 3, 154B subsection 8, 154B dash subsection 16. Subsection 3 talks about association of society. 8 talks about cooperative housing association. See, one is association society, second is cooperative housing association, and the third is subsection 16, housing federation. Now let us look at one by one. What do you mean by association of society? Here, minimum 5 societies are required, and that too of a housing society, registered housing society. And if there are 100 members, 4/5, that means 80 members should be housing society. Minimum 5 societies are required, and if there are, let us say, 10 societies or 10 members, in that case 8 members should be housing society. So 4/5 should be housing society, and 2 can be other societies, or it can be individuals also. So 20% can be other type of members, minimum 5 societies, and 80% should be housing society. Secondly, it is related to particular ward. Let us say K East Ward, K West Ward, A Ward, B Ward, C Ward, where we have divided into ward in Mumbai. But beyond Mumbai, we have talukas. So each taluka, or let us say locality wise, SV Road, MG Road, or Anand Nagar, Sai Baba Nagar, Haridas Nagar, where in a Ragar, more than 100, 250, 60 societies are there, where they want to manage a common areas, common garden, for those layout, or that ward or locality, they can be done. It can be corporator wise. See, in the Mumbai, we have wards. In each ward, there are about 10 to 12 corporators. Each corporator can consider it as a locality, and then they can come out with the association of society. This is the first. Second, there can be cooperative housing association. What is the difference? Cooperative housing association means, just look at the land in respect of a plot. If there is a layout, in the layout there are 3 societies, 4 societies, or 1 society, 1 condominium, 1 society, 1 company. In that case, they are called legal bodies. So there can be 2 legal bodies, 1 society and another legal body, or 2 legal bodies. Let us say there are 2 companies who are managing 2 housing complexes, they can come together and form an cooperative housing association. It is registered under 154B- subsection 8. Third is housing federation. Housing federation means a district level. So it is neither a taluka level, nor a ward level, neither a layout. In the layout, because you have to get the common conveyance. Say suppose there is one housing complex where there are A wing and B wing, there are two different societies, or there is a tower A and tower B registered as two different societies to manage their building, common areas. But in a layout, there is a garden, there's a swimming pool. For that, and to get a conveyance or basement where there is a common parking, they can form a cooperative housing association. Housing federation means it's a district federation. In Mumbai, we have two district federation. One is Mumbai City Housing Federation. Second is Mumbai Suburban District Cooperative Federation. So I am also part of Mumbai Suburban District Housing Federation chairman. So now let us come to the subsection 17. Now it is talking about what type of housing societies can be done. Here we have talked about apex societies, housing society and apex of that. Now we are coming to what type of housing society is possible. There are three types of housing society which are possible. First is tenant ownership housing society, where the land is owned by the society and the members are the owner of their own bungalow or a villa. In the case of a cooperative tenant co-partnership housing society, where the flats are owned and occupied by the members, but building and the land both are owned by the society. Tenant ownership, where building is owned by the members, society is the owner of the land or obtain the land on lease basis from CIDCO, MMRDA, or from MADA or a BMC or from a government. Tenant co-partnership, land is also owned by the society, building is owned by the society, members get an occupancy right. And then there are other types of housing society where earlier the premises society, office buildings, they were all registered as a separate premises society. But now they have formed a part of housing society. Now what is the advantage of this? The advantage is, in the case of, bylaws, now there will be uniform bylaw. Second thing, because now they are considered a housing society, we can also take a plea before the GST saying that now though it is a commercial premises, all premises are commercial, if our maintenance is less than 7,500, then because we are falling under a housing society, then we can always say that we are not required to pay GST on the maintenance less than 7,500 as per the notification. But earlier, that was not defined as a housing society. That was defined as a premises society. It was defined as a general type of society. And therefore, there was a confusion whether it can be considered as a housing society. Can we claim the exemption up to 7,500 for GST? We were saying no. Now, because of this inclusion of a premises society, house construction society, industrial premises society, house mortgage society, in other type of housing society, now we can take this play, because in GST, separately housing society is not defined or RW is not defined. So therefore, one can take the benefit. Now the next is defaulter. 154B1 subsection 11 means a member, flat owner, or a occupier who fails to pay the dues of the society within 3 months from the date of receiving the bill or a notice or due date of payment, whichever is later. Now, what used to happen earlier, the dues was not defined well. Secondly, in order to consider it as a defaulter, in order to consider it as a defaulter, we were required to give a notice. Now the bill is considered as a notice. So therefore, separate notice for recovery of dues need not be given, and once they don't pay within 3 months from the date of service of the bill or notice or even the due date of payment. Suppose a general body has decided that due date of the payment is 15th of every month, then even if you don't give the bill, it is understood from that there is a defaulter. So this way, this has been included. Second is very important. A defaulter is not a member, even an occupier. Now you may say how the occupier comes into picture. For example, a flat is owned by A and A has expired. Now it is occupied by one sibling and two are not staying there. But the one who is staying there, he does not pay the maintenance because he says flat is not transferred in my name, but he is enjoying the benefits. And therefore, such people are considered as occupier because they are not come as a member. In that case also they are considered default. Second situation, flat owner. Now many places what happens is a person owns the flat but he doesn't become a member of the society. He continues to occupy. Well, jab tak main member hi nahi hu, why should I pay maintenance? But now if they don't pay the maintenance, they are considered as a defaulter, and recovery action under section 154B 29, which I will be discussing a little later, can be included. Then we come to section 154B 12, where what is dues? Earlier there used to be a confusion about the dues, not defined anything. So a new definition has been inserted, means amount payable by a member, again, or a flat owner, or the occupier, it includes occupier, to the society and demanded by the society. One is to the society, payable by those people, by the society, to the society, and demanded by the society by issuing a bill or notice in writing. And such demand is based on the provisions of this act, rules, and bylaws. So one has to be very careful when we talk about what is act, what is rules, and what is bylaws. All three are very important for a person to understand and then act upon it. And therefore, anything within these three is very important. Now let us look at the types of members. You may ask, what are the types of members in a housing society? Who can become a member? What are their classification? So therefore, there are 4 classification of members. Let us look at 4 classification. First classification under section 154B, subsection 18 is member, person joining in an application for registration of a housing society, or who has become a member subsequently by way of transfer of flat or admitted as a member of the society after its registration, maybe by way of inheritance, by way of legal heirship, all that. So therefore they are a member whose name stands first in the share certificate. Second, there is an associate member. Now there was a confusion earlier, who can be associate member, how to make him an associate member. Now the rules have also made it very clear, and the associate members application form also has been given in the rules. So who can be a member? In section itself says that the 12 relations are prescribed: husband, wife, father, mother, brother, sister, son, daughter, son-in-law, daughter-in-law, nephew and niece. That means brother or sister's children. Who has to be recommended? Only these 6 relatives, and who has been recommended by the member to become an associate member. This is very important. Second, because they are not owning the flat or an apartment or a plot, their name will not appear in the shares. This is actually important because earlier associate member was not having a right in the property, but his name was appearing in the share certificate. That used to create a confusion. And therefore now it has been said, though they are admitted as an associate member for a limited purpose, their name will not appear in the share certificate. And they should be their relatives. Now the member has to describe and give an undertaking that they are my relative. And then third comes joint member. Who is the joint member? Joint member means one who holds the shares jointly with the member, with the other person. Say husband, wife. Husband becomes a member, wife becomes a joint member. Or if there is 4 children after the death of the member, elder son, 2 brothers and 1 daughter, sister. In that case, all 4. So remaining 3 called joint member. Who holds the share right title interest in the flat jointly, but whose name does not stand first in the share certificate. So the first in the share certificate is called a member, others are called joint member. Now the next comes provisional member. This is a new definition. Joint member and provisional member, even associate member, are all three new. Earlier, there used to be a nominal member. Now nominal member is no more required. That has been done away with. Earlier, we used to make a licensee as a nominal member because that particular licensee, if he does not vacate the premises or if he does not pay the maintenance, we could admit them as a nominal member and then recover the dues or get them evicted through the cooperative code. Now, for eviction of a licensee, there is a separate law, Maharashtra Rent and Control Act, and there is a separate competent authority. Similarly, because if he does not pay the maintenance, the defaulter includes the word occupier. So therefore, even on the licensee, we can recover the money and then we can evict them. So therefore, the nominal member has been done already. Now comes provisional member, means admitted as a member of a society temporarily after the death of the member on the basis of nomination till the admission of a legal heir or heirs in the membership of the society in place of deceased member. That means a nominee who is not a owner of the premise but a trustee, or a legal heir who has not been certified by any court, or he has none of the legal heirs have called them as a exclusive owner. In that case, they can be admitted temporarily as a provisional member. Again, in the rules it says their name will not appear in the share certificate. This way, provisional member name also will not appear in the share certificate. Now, the second question comes. Now that we have understood types of society, types of FX bodies, types of members, who is a defaulter, all that we have understood. Now let us come to registration of a society. A society now can be registered with a 5 members. That means each such person being a different family. What do you mean by family? Family means, for the purpose of this expression, member of a family means wife, husband, father, mother, dependent son, or unmarried dependent daughter. So husband, wife, father and mother, dependent son, and unmarried daughter are considered as a family. The rest of, suppose there are 2 brothers who are independent. No doubt they are maybe considered as a family member for associate member or in the bylaws. But for this purpose, they are considered as 2 different families, because that is how we want 5 different family members. If there are 100 units and 50 units are sold or 60 units are sold, out of 60 units which are sold, out of that more than 51% should become a member to register a society. Thirdly, he should become a qualified to become member under this act, because section 22 talks about who can become member. Member can be an individual, HUF, all that is given there. And join the registration. So they should join the registration of the society in the beginning so that society can be registered. So this way, we need 5 people, more than 50% of the sold unit owners should join the registration proposal. So this way, society can be registered. Housing society can be registered. No tenant co-partnership housing society or other tenant ownership society, all type of societies or other type of society. Now, application for registration, as we said, minimum number, that is 5 are required. If you are going to do the association of society, then minimum 2 are required. Cooperative association, association of society, you require 5 members. Then rules. Now let me come to the rules. Rule has defined that first you have to apply for name reservation. Because you have to apply for the name reservation form is given to you, Y1. Then you have to have 5 or more members should come together as a chief promoters. They should pass a resolution electing the chief promoter. Then there should be a commencement certificate, or there should be society which has got a tentative plan certified by the architect or a sanctioned plan. So these are the some of the minimum document required as per the rules to register the society. I'm not getting into much. Then every application for name registration should be in form number Y2, which is given. List of office bearers who are attending in the case of association to be given. And as I said, in the case of association society, you need 5 members. In the case of cooperative housing association, you need 2 people. So office bearers should be authorized. A certificate from the architect is required that this is in the layout or in the same locality, so that registration becomes easy. So application for name registration, register, once it is received, he maintains a register. The register will dispose of the application within 30 days. These are some of the provisions in the rules. So procedural aspect is given. So now if you have to register a society, as I said, then you have to make an application. For that, form number Y1 is prescribed. And section 154B2 gives various conditions, and certificates of name reservation has to be obtained. You have to open a bank account, you have to deposit the share money, get the balance certificate, and then you have to show the scheme of working as to how many flats are there, how many shops are there, how the common areas. So with all this, a society application can be made, and the society will be registered within 2 months from the date of making application or removing the defects. This is how a housing society can be registered, or an association of cooperative society can be registered, or cooperative housing association can be registered. Now comes registration fee. The rule 106C3 says that depending on the number of members, the registration fee earlier was a flat registration fee of 2,500. Now, depending on the number of members, the fees have been prescribed. For tenant co-partnership, ownership housing, so it is 5,000. Tenant co-partnership up to 25, 2,500, up to 26 and 50 members, it's 5,000. 51 to 250, 7,500, and about 250, 10,000. And for a housing association or others, it is 5,000. Now, if there is a backward society, Lok Awas Yojana, in that case, it is 50 rupees, and cooperative housing association, then it is 5,000. Other type of housing societies, that is mortgage societies, all that, it is 5,000. Association housing society also, it is 5,000. So the application can be given by registered post. Now online provisions are also made, or you can, that is why it is written electronic mode, online application has to be done, or you can do the hand delivery also. Now let me take you to the sub 4, 154B. What are the rights of associate, joint and provisional? Let me tell you, section 22 talks about conditions for membership, and society may admit any person as associate, joint and provisional member who are also entitled to become a member under section 22, and they have a right to vote. All these 4 types of members, please understand, all these 4 types of members have a right to vote and as well as contest. However, they are subject to provisions of subsection 2, 3, 4 of 154B11, which means under this 154B11, they have said in the case of an associate member, the consent from the member is required. In the case of a joint member, consent of the first member is required. But there are no other conditions which are prescribed for contesting and also to vote. So therefore, this, when I discuss 154B11, you will know. Now let us look at limit on membership. As I was saying, the number of members in a housing society cannot exceed the number of flats or plots which are approved in the plan. Earlier, with 10 members, one used to get 100 acres of land with 10 members. And sometimes the member used to be 1,000 and building used to have 20 members, 20 flats. What will happen to 980 members? God knows. So therefore, now the law has been made very clear that number of members in a housing society cannot exceed number of flats or plots allotted or approved. And therefore, when we are going for redevelopment also, the additional members cannot exceed number of flats. However, in a case of plots, it also sometimes happens that each plot owner is a member, and in each plot there can be one more housing society. I'll give you an example so you will understand. Now there is a bungalow type of societies where each plot is having say 5,000 square feet, 500 square meter. Now after 30-40 years, now there is an additional FSI that 500 square meter they want to construct a multi-story building, wherein let us say there are 8 apartments, flats. Now those ground floor is retained by the owner, remaining 7 apartments or flats are sold. Then they independent plot having an independent building can have one more housing society, and that housing society now can become a member, provided that the plot owners cooperating society may admit to its membership an organization of housing society or a company association of flat purchase in case of plot owner had constructed sold apartment as per prevailing rules in place of original flat owner. Sorry, plot owner. So this is how the limit of membership is given. Now let me take you to the next very important provision, rule number 106C4. Now, what are the conditions to be, because now I am talking about procedural aspect, which is on 18th June 2026, it has been mentioned. No person shall be admitted as a member except associate or provisional member of a society unless he applies in a prescribed form, he pays 500, at least 5 shares, and entrance fee of rupees 500 is written here. Actually, in the Marathi, it is written 100 rupees, and English, it is written 500 rupees as an entrance fees. So maybe it's a printing error, but now we'll have to go according to the English version, unless until some clarification comes from the government. Now the entrance fee can be considered as 500 rupees and 250 rupees share money, at least 5 shares of rupees 50 each. So that should be paid. There should be agreement. There should be gift deed, registered gift deed. So if in case of a transfer, there can be a family arrangement or various other testamentary, and his application can be approved by the managing committee. See, earlier, people used to have a confusion whether the membership is granted by managing committee or by the general body. Now this has been made very clear that the membership in a housing society is granted by managing committee. So therefore, these are some of the things. Now it comes, if the application is made by other than under 154B120, subsection 20 talks about persons who can be admitted as a member. Person talks about individual. So individual can apply himself, but then comes HUF, then comes partnership, company, all these, there are about another 11 types. Association of societies, cooperative society, trust, a local body, all these can become member. In that case, they have to come out with the accompanied by a resolution authorizing it to apply. So that means other than individual, there has to be a resolution to that effect. And this is also applicable for the purpose of voting, also attending the meeting. Now let us come to the next is very important, is rule number 106C5. How you can become an associate member. I have just explained you who can become an associate member. And how you become, in order to become an associate member, then you have to apply in form Y5A, which is prescribed in the rules, recommended by the member. And now the question comes, when the associate member ceases, not defined in the act. So in the rules it says, they cease to be the associate member on happening of 3 events. What are those 3 events? 1, on the death of the member, original member who has recommended. Because original member is gone, that means associate member also is gone. Second, on the request of the original member. Suppose today I have recommended my son to become an associate member. Tomorrow I find that son is married, now he is not living with me, he is abroad, he doesn't have the contact, now he is not able to give me a resignation letter. I, being a person who has recommended his membership, I can write a letter to this society and cancel his associate membership because I have only recommended. So I can withdraw. The third important is the associate member himself can resign. He is not able to perform his duties, so he can resign. Or death of the fourth is on the death of the associate member. Again, how can he continue? So these are the four incidents where a person ceases to be an associate member. Now, procedure for admission of provisional member, as I said, we have talked about associate member. Now, how provisional members are admitted? Provisional member is admitted, as you know, there is a form number Y4. Again, it is prescribed in the rules. So one need not go to the bylaws. Secondly, a person who is a nominee on the death of the member can give the death certificate and give an indemnity bond, indemnifying the society against any future claims regarding shares or interest of such deceased member. And if there are more than one nominee, all the nominees shall make a single application. So earlier there was no clarity. If there are multiple nominee, how can you do? Now it has been made clear that if there are multiple nominee, so all nominee have to come together and make an application. Now where a member of the society dies without making nomination also possible. In that case, or it is also possible where the nominee will not come forward. That is also possible. In that case, the legal heirs can come together among themselves. They can say that the legal heirs will apply for a provisional membership till they get a proper documentation done. In that case, they have to give advertisement in the two local newspaper. And then if there is no claim, then society can, of course, they have to put on the notice board also, and they can admit a legal heir who has applied for a membership to become a member of the society as a provisional member. After taking into application received and after making such inquiry, company deems fit, in that case, a provisional member can be admitted by taking indemnity. Now, if there are more claimants than one, in that case, they have to file an affidavit who should become a provisional member if there are more claimants. Secondly, if they don't come together, then the committee may call upon them to produce a legal heirship certificate. In that case, they can call for a legal heirship certificate or a succession certificate or a letter of administration to the committee. That is possible. A provisional member, he ceases when, that is also equally important. The way I said, associate member ceases on his death or resignation or recommendation is withdrawn. Similar way, a provisional member shall not, the provisional member ceases to be a provisional member once the names of the legal heirs are brought on record. Once the legal heirs are brought on record, because provisional members' names are not entered in the share certificate. Very important. See, G, a provisional member shall not have any right, title, interest in the ownership of the property, and his name shall not be included in the share certificate. So it is made very clear. So therefore, on the moment legal heirs are brought on record, the provisional members' name gets deleted. Now, 106C62, procedure for transfer on the basis of family arrangement. As I was saying, that family arrangement, without going to the court of law, even the will now, as you may be aware, that we don't have to get it probated because Indian Succession Act 1925 has been amended. Now, since will need not be probated and there are multiple wills, or let us assume that there are no will, nothing, but there are 5 legal heirs and they can enter into a family arrangement saying that who will become a member. They can enter into release deed. And what is family arrangement? That also is written. Family arrangement means an arrangement or a settlement reached between the legal heirs or representative of the deceased member of the society. Now, many people were asking, even in the High Court, there is one judgment which I will discuss a little later, that in order to prove that you are a legal heir, you need to come out with the legal heir certificate from the competent court. Answer is not required. Absolutely not. Because if there is a dispute, then yes. If there is no dispute, then you don't have to. So the legal heir shall thereafter make an application in form number Y5. See, earlier you have seen provisional members are in form number Y4. And now it is form number Y5. and for an associate member, form number Y5A. So this way, the forms have been prescribed in the rules. The legal heir shall thereafter make an application in Form Y to the society along with the duly registered deed of family arrangement. So that means the family arrangement has to be registered. An indemnity bond indemnifying the society against any claims made to the society, right title interest in the flat. Now, just to give you an example, you may say, sir, we are having 5 children and we have decided that we want to have equal 20% share. Then can a family arrangement be done? Can it be registered? Answer is yes. You can certainly get those family arrangement saying that everybody will get equal share, and because no shares are getting transferred each other, that arrangement can be registered on a 500 rupee stamp paper and then produced before the, because that becomes a registered document. And once we, and again you are also going to make an affidavit saying that these are the only 5 legal heirs. If there is a dispute, then all the legal heirs will face the music. So therefore, one has to be very careful. Huh? Okay. So now we have to quickly proceed. So 106C procedure for transfer on the basis of family arrangement I have discussed. There is one more 154B6 section which talks about cooperation, education and training. It's again very important for every society, housing society to do, because one of the objectives of the principles of cooperation is to have education and training. So therefore, there has to be education and training, which has been defined here. Now the rules prescribe that sub-rule 3, you just look at that as far as possible period of education is concerned, for member at least one session of 3 hours annually has to be done, for which you have to collect 10 rupees per member per month, and then for committee and office bearers and employees, that is a manager and all, you have to have 2 sessions of 3 hours, that means half yearly once you have to have. Now, education and training can be done through a notified government institute or by the state federation, which has been given, and that is how one can look into. Now, restriction on transfer of shares is very important. The dues of the society should be paid. If you don't pay the dues of the society, you will not be admitted as a member of the society. The transfer fees applies and acquires membership of Common Society in the due course of time. That means if you want to get the flat transferred, and if there are dues, unless until you pay the earlier dues, you cannot become a member. I'll give you some examples. Sometimes what happens is the societies do, in some places, person buy under securitization, auction, and there are old members whose dues are outstanding, and sometimes the old member says, I'm not going to pay the money. Why? He is not going to pay. That means he is saying, I was not the member, neither I was aware. But sir, you are taken on the as and wherein basis, and dues have to be paid. And therefore, there is a Bombay High Court judgment which has been categorically said, unless until you pay the old dues, your membership will not be transferred. Now, the rights of the member is also equally important. The member has a right to get the, because sometimes members ask for vouchers, they ask for a bank statement, they ask for the ledger account of all the members. No, they are not entitled. They are only entitled for these 9 items. Let us look at them. One is the copy of the act, rules, bylaws, the last audited balance sheet, not 40 years old audited balance sheet, only last year. Profit and loss account of the last year, list of members of the committee which is recently elected, register of the members that they are entitled, minutes of the general body, minutes of the managing committee. Yes, because the cooperative housing society is an institution. Institutional memories are captured in the form of minutes. So they are entitled. And only those portion of books of account, that means ledger account of his, he cannot ask for other ledger account. He cannot ask for vouchers. These are the things. So they can get free of cost inspection. But if they pay the money, they can get within 45 days of making the payment as per the bylaws. Whatever the fees prescribed, they have to pay, and they can get within 45 days. In the case of a government aided societies, then the RTI is applicable. Therefore, that is 30 days are given. Now, offenses, if you don't, furnish all these documents, then it will be treated as an offense. Then nomination of persons, which we have already seen, any member can make a nomination. Suppose if there are two members, ownership 50-50, then two nomination can be done because there was no clarity earlier. Now 106C sub rule -8 says that removal of a member, yes. Now the registrar has a right to remove the member on the basis of the complaint. The rules are not followed, or so moto also on the inspection, registrar comes to know that some anomaly has happened and there are no flats are 100, members are 125, 25 members don't have any flats. In that case, those members can be removed by the registrar because they don't have the apartment. Similarly, rights and duties of the members. Every member has a right to receive the allotment letter. He has a right to receive the share certificate. He has a right to contest the election. He has a right to contest the, all these are prescribed in the bylaws also. Right and duties of the member, he has to occupy the apartment, he has to use, he cannot contrary the act and rules and bylaws. No member shall be eligible for being appointed, nominated, elected if he is a defaulter of the society. He cannot contest the election if he is a defaulter. Rights and duties of the member, it shall be the duty of the member to pay the dues. As I said, he shall vacate the place for the redevelopment. This has been now made as a obligation on the member. Suppose a member does not vacate, we can still go to the cooperative court because redevelopment is also the objectives of the society. Members shall perform all duties prescribed in the Act, rules and bylaws. Then also member have a right to contest the election, which I said, to the committee with the previous written consent of the member. Any action which is there in the original member, if the first member is a defaulter, then on his behalf, associate member cannot contest. So voting rights of the member, no member of the society will have more than one. Suppose I as a member has got 2 apartments and I have 2 votes. Answer is no. Suppose the first apartment is owned by me, second apartment is owned by my wife, then we are 2 members. So therefore we have 2 votes. First flat is owned by A and B. Second also is owned by A and B. Then who is the member in both? A is the member. And therefore they will have one right. Also member shall have a right to vote with the prior consent of the member. Member has to always give a consent that he is also a member, I can. And provisional member has a right to vote because they have the right to vote. Therefore they have a right to contest. In case of association of society, authorized member or a housing society, authorized member can vote. Transfer of shares, yes, member may transfer his share, right, title, interest in the property by way of registered document. Earlier, without registered document, one could have been made a member. Now there has to be registered document. Even the act has been amended to that. Transfer of interest of the member of the deceased member. Yes, in the case of a deceased member, I said initially they can be made as a provisional member. Thereafter, if they bring the relevant document like legal heir certificate, family arrangement deed, then they can be converted into regular member. Nomination of the person, yes, a nomination can be done jointly. We have seen. Now let me take you to one of the very important judgment. Vipul Patechand Shah versus Deputy Registrar Cooperative Societies. 6th April 2023, it has been decided. On the death of the member, society must deal with the transfer of deceased member's share, title and interest on the basis of testamentary document, succession certificate, legal heir certificate, family arrangement, or a valid nomination. A nominee is ordinarily admitted on a provisional member until person legally entitled to that established. In this case, a provisional member was not admitted, nominee was not admitted, and they had to go. And then the court said, yes, you can provisionally admit. So Bhima Nagar is another case where what happened was the society refused to admit them as a member based on family arrangement deed. The matter went to the Honorable High Court on 23rd September 2024. High Court said, no, family arrangement means a release deed, and therefore release deed, relinquished deed can be considered as a family arrangement, and therefore based on that, membership was granted. Now, charges, section 154B14 says, society shall have a charge upon the share and interest of the member, past member, deceased member to the extent of dues payable, because dues can be recovered as areas of land revenue. If a member does not pay the dues, yes, we can recover as areas of land revenue. Similarly, creation of funds. So the fund can be created as prescribed in the rules. So I will just deal with the rules. Recently, the rules have been made that funds have to be created in a certain manner, and such funds from time to time shall be decided, prescribed, and it can be as per the bylaws also. So the rule says it will be prescribed under these rules and then as per the bylaws. Now I'll take you to the creation of funds. 106.11 it says there will be reserve fund. Reserve fund is as per the Act, section 66. Transfer fee, admission, all this will be entrance fees, all this will be reserve fund. Sinking fund, 0.25% of the per annum of the construction cost of each flat when the building was constructed. Similarly, repair fund, 0.75% per annum of the construction cost of the each flat incurred at the time of construction of the building as certified by the architect. So therefore, there was a lot of confusion. So now that has been done away. And this fund can be used for recurring expense. Major repair fund, yes, society can collect major repair fund based on the area of the plant. Education and training fund, 10 rupees per member, which we have already discussed. Election fund, yes, for the once in 5 years election is going to happen, so you can create an election fund. Welfare fund can be done for conducting social media, social activities, annual sports or recreation activities, sports, or maybe 26th, maybe let us say 26th January, or maybe 15th of August, or maybe 1st May. Corpus fund, society may maintain a corpus fund. Any other fund with the permission of general body can also be raised. Then levy of charges is given under 154B16. It says society as prescribed can create various charges, and this can be invested in the district bank or in the nationalized bank. Now levy of charges, yes, service charge, property tax, water charge, these are all. Now you may say why all these are given in the rules, because many times housing society used to say that our bylaws does not contain all this. They used to pass a resolution and they used to charge in whatever way they think. But now the rules are prescribed. Once the rule comes, it becomes a mandatory, and therefore the rules are given. And how this should be, what are the things included in the service charges also is prescribed in sub rule 2. And then levy of charges, on what basis charges will be distributed. Service charges equally, property tax as fixed by the local authority. Water charges on the basis of the tap. Expense on repair equally if it is regular maintenance in the case of lift and reinstallation of the lift. Parking charges at the rate fixed in the general body as per the parking policy. Interest cannot exceed more than 12% per annum. Earlier 21% was permitted in the bylaws. Now it is 12% simple interest. Repayment of installment on the loan also as fixed by the financial institution. Non-given charges cannot exceed 10% of service charges. Insurance as per the area. Lease rent as per the area. Sinking fund we already discussed. Repair fund 0.75%. Major repair fund, education fund, all 10 rupees per member. All this is now given in the rules itself. Investment of the funds, as we discussed, it can be invested in different securities also, which is permitted under Indian Trust Act. Now we are talking about committee shall be as per the government. Now up to 50 members, there can be 7 members committee, and 50 to 100, or there can be 11. So like this, the bylaws also prescribes the committee, and there should be 2/3 committee which should be elected to form the quorum. If there are no 2/3 members, then committee will not. Say, let us say 9 is the constitution. 2/3 means minimum 6 members should be elected. Then only the committee can be constituted. And this will be done by the returning officer. So reservation of certain seats on the committee, women seat and reserve categories like scheduled caste, scheduled tribes, 1 member of nomadic tribes, other backward class is also prescribed. One can have them. 1 member belonging to denotified Vimukti Jatis. Any individual member of the or elected member of the society co-opted also should be belonging to respective class only. Now we are talking about reservation. In case there are no reserved category, you will have to keep those vacant. So now we are coming to the women. 2 women has to be elected in every society, even though there are 7 members in the minimum, less than 50 members. In that case, 2 should be women and 5 can be general category. So strength of the committee, as I said, for the purpose of calculation of 2/3 at the time of quorum, for the purpose of quorum, that reservation can be eliminated, because we have represented in housing society, sometimes you don't get a reservation. Disqualification, yes, if he is a defaulter and if he carries the letting out business in the society and he is disqualified under few sections, then he is considered as a disqualified. And if he has more than 2 children, means 3 children, then they are also disqualified. So then disqualification is further continued, and there are case laws also where Shahid, Tamboli and others, Division Joint Registrar, the court considered an obligation of housing to support the documents informed, because certain documents were not given and therefore that was disqualified. Member was disqualified because he has not given the document what is demanded. So motion of no confidence can be done where the meeting will be presented in the office of the registrar and minimum 2/3 members, less than 2/3 majority of the committee members who are present and entitled to vote at such meeting. So the quorum for that meeting will be 2/3 and majority should be accepting it, and then only. So the no confidence is possible. Management of housing society, yes. So for the purpose of housing society management, now the rule says the commissioner is going to come out with a separate bylaws for housing complex, association, and also housing society. Management of housing society, adoption of bylaws. Now, please read this. The management of every society, association, or cooperative shall be governed by the bylaws of the society approved by the registrar. Bylaws of the society shall form the core governance framework of the society. That means now shall be governed. Even if you don't adopt the new bylaws, now the moment the Commissioner of Cooperation prescribes the bylaws, that becomes binding and applicable. However, the societies can still adopt it. If they don't adopt also, one of the judgments of the Honorable High Court says many societies don't adopt and therefore they will be deemed to be adopted. Similarly, a deeming provision has been put here. The word deeming is not written. It says management of every housing society, association society, cooperative society shall be governed by the bylaws approved by the registrar. That means registration cooperative commission. Duties of the managing committee also has been prescribed under subsection rule 2. Now the general body can be done under 106(13) online. Now it is possible. Audio-visual means a member of a society who is abroad or outside the building can also participate. This is very important. Now the general body for the redevelopment will have to have 2/3 members as the quorum, and more than 51% should be giving approval for redevelopment. And such, again, redevelopment meeting also, the member can participate video conference and registrar's representative present in the meeting. So casual vacancies now can be filled by the committee. Committee only they can fill up. Now there is one judgment of the Honorable High Court which says you cannot co-opt more than 1/3 of the members in the co-option, but 2/3 you have to continue to be elected. 1/3 maximum can be co-opted. Management of the housing society, it's a housing society managing committee who is responsible to take care of day-to-day affairs, including repairs and maintenance, and up to 25 members 1 lakh, 26 to 52 lakhs, 51 to 100 3 lakhs, 101 to 1000 members 4 lakh, and above 1000 members you can spend 5 lakhs per society per incident as repair expenses. Earlier bylaw was saying not more than 1 lakh. Now the rules have prescribed. Allotment of the plot, as I said, the number of members cannot exceed. So therefore, allotment of the plots has to be done, cannot be done contrary to the act, and it cannot be more than one plot. It says is other dwellings shall be made by the committee. It's a committee who will be doing, especially based on the lottery system. And it, of course, it will be recommended and it will be general. Every member of the housing society, whether registered before or after the commencement of this act, okay, shall be issued a certificate of allotment, which I was just talking to you. And now, if the managing committee does not perform certain obligations, then registrar, we can apply to the registrar and get the action initiated. This is also very important. The obligation of society to take actions. And now it is a registrar with whom you can complain. Section 28 says Housing Federation now given a lot of responsibility of collecting education and training, maintaining the managers panel, recovery officers panel, so that a lot of grievances can be taken care by the Housing Federation also. A lot of powers are given. Now, then we are talking about recovery of this. Now, recovery can be done by the registrar under section 154B29, and now there are rules which are being prescribed. One can go to the registrar and get the recovery certificate, and one can recover. And therefore, there are rules granted. 106C14, grant of certificate of recovery is given where one has to make the application in Y6, and application will be accompanied by the authority letter and other things, prescribed resolution, bill, statement of account, and then the registrar will carry out the scrutiny. He will conduct the hearing, appearance of the party will take place, production of document takes place, procedure of hearing takes place, and then the registrar will give the order in Y7 form, which will be reasoned order. So there are some case laws. Legacy Cooperative Society Limited versus Deputy Registrar on 19 March 2024, it has been said that a special mechanism for recovery of society dues, including repair, maintenance, construction costs, has been done, and certificate can be issued. Provisions apply to recovery of all the dues, in respect of the cost of the flat also, and maintenance dues. In the case of Smita P. Dalvi, also Supreme Court, High Court has said that recovery mechanism is given under 154(29). Then Sudhakar Roman Pawar also, which says that yes, recovery can be done. So Prestige Cooperative Society also given some judgment which you can go through. Last two sections, House Building Cooperative Society, once the objectives are achieved, now you can deregister the society. And last is saving clause. If there are certain provisions, act rules, which is not having a relevant circulars, old circular which is already issued under the old act, that will be applicable. With this, thank you very much. I know I have taken a little more time, but I thought I should complete. Thank you, Apurvaji. I have received your message that I should.
But sir, thank you so much for covering everything. So we are really grateful to you. I'll request Raj and Aditya to take some of the questions which are there in the box.
Yeah, sure.
Thank you very much, sir. Thank you, Prabhu, sir, for such a comprehensive and practical sessions. I can already see a lot of appreciation from attendees. We will now have some Q&A for members who are watching this session live on YouTube. Are requested to put the questions in the live chat. Our team will also ensure that they are clarified. Some questions to begin with on the chat box is whether model bylaws still need to be adopted by general body. What happens if a housing society does not adopt the amended model bylaws? Which bylaws will prevail? The one which have been already adopted and registered with the registrar, or the amended ones as notified by government, sir?
Great. I think the rules I have just explained you,
Sir.
that 106C, the rules, it says once the registrar approves the bylaws and prescribes it for the society to adopt, whether they adopt or not, that shall become compulsorily applicable. So the adoption is an option to you, but that does not mean that now old bylaws are there, I have done this, I have done that, nothing. Now, therefore, a lot of things have been put in the rules. Rules become mandatory. It is prescribed. So, therefore, the government has taken about 6-7 years to publish the rules. And each of the rules have been debated, discussed, suggestions, objections have been invited, and now it has become the law of the land. And therefore, it has been approved by the cabinet, gazetted, and therefore, now the rule says that whether once the Commissioner of Cooperation approves bylaw which is under preparation, once it is approved, all the old bylaws become redundant, new bylaws applicable, and it will be governing to the society. They don't have to adopt. It is considered as adopted. Okay.
Thank you, sir. Next question is, does flat include a terrace which is in occupation of the flat owner?
See, the question is, there are two types of terrace. One is a private terrace, okay, which is because of certain restrictions, it has its own entry. The terrace could be something like a balcony. Okay.
Yeah.
In that case, yes, it is no doubt. As per RERA, it is not considered as a carpet area. It is outside the carpet area. Balconies, verandas, or this type of terrace is not part of the area. However, a builder can always sell, and that becomes a part of the flat. Now the question is whether it has a FSI. I will have to see the approved plan. If it is a part of the FSI, naturally in the new plan redevelopment they get. If it is not a part of the FSI, in that case, in the new plan, when the redevelopment happens, whether they get or not, I don't know, because that need to be negotiated. However, the question is limited question, whether it is a part of the flat. If it is a private terrace without any entrance of the common, yes, it's considered as a part of the flat, but not a carpet area. And if it is a common area, which builders sometimes give both, you have a terrace entry and there is a common entry also. In that case, it will be considered as not a part of the flat.
Next question, whether interest on delayed payments by members chargeable to income tax?
See, income tax is a separate chapter altogether, but let me make it very clear. Housing society, any contribution which is received from the member is covered under the concept of mutuality, where n number of Supreme Court judgments are there, and it is well accepted. They are not liable for tax. Just to give you an example, even the transfer fee, many society used to charge more than 25,000. Okay, so in that case also, the Bombay High Court has said that the tax is not applicable, income tax is not applicable. So concept of mutuality is applicable. So whether it's a parking charges, non-occupancy charges, social welfare fund, transfer fees, and you will create a lot of surplus. They are not called as a profit. They are called as surplus, contribution from the members. So therefore, they are not liable for income tax.
Next question, can a chartered accountant use residential flat to carry out profession? The flat is wholly used for profession. Does any permission required from society or corporation?
Yeah. Yeah. Yeah, 1 minute. I think you are not able to see the camera. Now, okay?
It is
Okay.
visible, sir. Yes, sir.
It
Yes,
is
sir.
Yes, clear.
Yes,
Okay.
sir. Yes.
Now let us look at this. Can I, what is your question? Can you please repeat? Yeah.
Yes, sir. The question is, can a CA use residential flat to carry out profession? The flat is wholly used only for profession. Is any permission required from society or corporation?
See, first of all, under Article 19 of the Constitution, everybody is entitled to carry out the practice which has been permitted. Whether chartered accountant, advocate, or architect, engineer, these are all personal skills. Now, these personal skills can be, practiced either at a residential place or in the specially commercial premise. Now, the question is, yes, in the case of DCPR, it says that when I say development control and promotion regulation, when the plans are getting approved in Mumbai and Maharashtra, it says 30% of these use can be for other than dominant use. Dominant use should be residential. Now, question arises, let us assume 100% flats, I'm using it for a commercial purpose. Now, just because I have to be residing, that does not mean that I have to have a bedroom. I may be staying here. Staying does not mean that I have to sleep. Staying does not mean that I have to have the, their kitchen and I have to be cooking. My entire office environment may be looking as I have done the office. So still one can say that my dominant use is to stay, and with that I'm doing. And there are n number of High Court and Supreme Court judgment which says that technically practicing chartered accountant advocates, they are not covered under the Shop and Establishment Act, and therefore they are allowed. Now the second question is whether you need a permission. If you can take the permission, nothing like it. I am doing in my residential flat 100% office. I have taken the NOC from the society. For that, society charged me 50,000 rupees. I paid, and they said you will be charged 1.25 times of the maintenance. Others, we are charging 100 rupees. For you, 125 rupees. I
25,
said,
yes.
okay. So, see, some type of adjustment if you are able to do. Now, the question arises whether the government will take an objection. The municipality may come on the complaint. They may take objection. They may convert the residential into commercial property tax. Electric department may charge from residential rate to commercial. All this can happen.
Okay.
Society per se cannot evict.
Cannot. Yeah.
You can still continue to use 100%. There should not be a problem.
Thank you, sir. Then next question, can a general meeting of members be conducted through virtual or electronic means or hybrid mode? If yes, what are the applicable provisions and procedures?
Yeah, great. So I was discussing about the general body, whether it is a redevelopment general body or a special general body, AGM. It can be now done on the hybrid basis, or even I would call it as a hybrid only, because chairman, secretary, committee or majority may be sitting at one place. You have fixed the venue, and majority also can come online. So it is permitted now, even the redevelopment committee meeting, because now we know that a person, NRI, also can own a flat in the society, and he can become member, and his rights cannot be deprived. And now video conference also is considered as the personal participation, because one can see now also we are on the webinar.
Yeah.
So post COVID, now video conference has become common, and now officially it has been permitted in the rules.
Thank you, sir. CA Aditya ji, can we take some questions on YouTube? If- You can continue, sir. Or
Yeah, there are questions. Can you please
yes, sir.
clarify in detail tenant ownership housing society, tenant co-partnership, and other type of society? See, as I said, there are two types of societies which are getting registered. One is tenant ownership, means it is more like a bungalow type, where bungalow is owned by me and the land is owned by the society. That is called tenant ownership, because you are owning the building and all management, maintenance of that building is with you. Second is tenant co-partnership, where land and building both are owned by the society. So therefore they are tenant co-partnership. In the case of other type of society is like premises society, office building society, or industrial premises society. They are all premises society, is other type of society. Okay. Now Aditya has asked one question. The original leasee of the plot of the land under the estate department assigned the plot to one CHS in the year 1965 through an assignment deed, which was not registered with the sub-register. The said CHS then transferred the plot to another CHS in the same year through a registered assignment deed. The said CHS then built a residential building, which is now being considered for redevelopment. The estate department record still shows the name of the original leasee. What are the implications? Sir, you will have to see how the BMC looks into it. If at all, if they are not permitting, they are saying would deed also need to be registered. You have two options. One, you can go under the deemed conveyance and try to get it regularized, or else you will have to move in this. Actually, because a lease, naturally you will have to go to the small causes court and get the decree from the small causes. Whichever is convenient, you can do. But deemed conveyance also should be possible.
Yes, sir. Aditya ji, any questions on YouTube we can take in the meanwhile? Yes, Yes, sir. 1 minute. So can you hear me? Yes, okay.
Yeah.
Yes.
So there is a question on YouTube. It says that 147 member allottees are there, in which whose developer has not finished the project of 240 flats. RERA wants to hand over incomplete buildings under Section 8 of RERA to the housing society, but the housing society has no resources. Is there any way forward?
Sir, he has not asked anything related to housing society.
Yeah, ये तो
But-
sir बहुत specific question. I think we
But
can skip this.
I'll answer it in a very small and a brief. Sir, once an association of allottees are done in the redevelopment, all the people who have purchased the apartment should be made as a member. And once they are made a member, everybody considers to be the associate allottee. And if the builder has run away, he is behind the bar and he is not able to complete. Now, whose collective responsibility is to complete the building? Because you are the equity owners. So therefore, all the people have to contribute, come together. If you don't have the money, then don't complete the building. Leave it as it is. Section 8 of the RERA says that it is an obligation of the RERA authority to get the building completed through the association allottee or through the common authority or by themselves. Now the association allottee has gone to RERA, asked for the handing over of the building for the purpose of completion, and now you are saying that we cannot do. Okay, go to tell RERA that we cannot do. Then let the RERA make a tender, publish, and that may take another 20 years. Wait for that. It is all related to the stall project. I have done one stall project of Mehul Choksi in Borivali, where it was ED attached, where the BMC had attached, where the contractor had put his laborers there. But we went to RERA, we got the order, we contributed about 40 crore, and we got the flat which was Bangar, means we got ED attachment release, we got BMC release, we got the OC, we went to High Court. We have to spend money, and the flat which otherwise would have been zero value, we could now 2 crore people had paid. Now they are selling the same flat for 4 crore, because you have to spend little money to get the value for the investment that you have done. So therefore, you cannot expect the RERA to do all this. You are undertaken. So please complete the stall project by contributing yourself, and all this money is recoverable under MCS Act as a dues, and under the RERA also it is recoverable. So some members don't pay, you can auction their flat through RERA or under the MCS Act and recover the money.
I think we'll go ahead with any other questions from Zoom.
Yeah,
also,
Kaushik
because
Bhai
these
has
are
put
very
a question.
general comments.
Yeah,
Yes.
Kaushik Bhai has put a question. Can a member insist that all the notices and circulars be sent through an electronic mailing system consistently, with the manual copies provided only as an exception to members who do not have access to online? The answer is yes. You can always pass a resolution in the general body, and now email is considered as one of the group. So therefore, what I normally tell the people, that create a Google group of all your members, because it goes in the, instead of WhatsApp group, create a Google group, one-way communication, all notices, everything you send in the Google group. So it becomes a complete record and transparency. The Ravindra Turanga has a question. Yeah. He has asked, Association of Cooperative Society, can it be formed less than 5 souls to maintain common amenities? I told you there are 3 types of apex body. One is association of society, which is more than 5 societies required in a layout, not in the layout, in a local area like a ward or a municipal corporation, or in the locality, a big 100, 200 societies. Whereas what you are asking is to maintain a common amenities. To maintain a common amenities in a layout, you have to form a cooperative housing association, where you need only 2 societies, where you can get a deemed conveyance or a layout conveyance in the name of cooperative housing association. So you don't have to form a cooperative housing society association. Yeah.
The next question is a bit specific. Probably you can consider if
Specific ones, Raj, specific ones we can
Okay.
skip.
Okay, sir. So we'll skip. And other than the distinction mentioned in section 154B18, can we make other distinctions among members, like resident member, non-resident member, member who owns flat but has given it in lease and is staying in a rented flat in the same society, especially with regard to enjoying common facilities and use of common area or parking slots? So,
What happens? We are talking about types of members.
Hmm.
In the types of member, we have only 4 types. One is a member, associate member, joint member, provisional member. You want to call them a resident member, non-resident member, you want to subclassify. This is not permitted in the Act and rules, neither in the bylaws. You want to pass a resolution, you want to maintain a separate register. These are the outstation member, these are the non-resident member, these are for the purpose of your communication. These are the people whom you want to, they are the senior citizen member whom you want to give hard copy. These are the people who are, accessible online. All that you can do. See, we have done by taking a application from the people who want soft copy, and they have given the email address. Then we have classified. These are the people who want online meeting. These are the people who want online resolution, communication. So others, that means hard copy. So this way one can, internal management, how you want to do, managing committee can pass a resolution and maintain a separate register. But you cannot classify them and give them a different rights. The right has to be same for everybody as per the prescribed 4 classification. Okay.
Whether an associate member can become a committee member, sir?
Absolutely. Associate member with the consent of the first member can contest the election and become a committee member. Secondly, even the provisional member can become, joint member can become, no problem. They are allowed to vote, and therefore they are allowed to contest. Now there is Ananda Kumashi. If a society registered in 1968, husband was owning the flat and his wife owned the garage. After expiry, husband flat is transferred to wife's name. This society is going for return. What will happen to the garage? 2 membership for person wife, please advise. See, we will have to look into the document whether 2 membership was granted, 2 share certificates were granted, and it is a closed garage. If that has been permitted under the old bylaws and old act, then it can be continued. Suppose there is no separate share certificate, it is 1 flat, 1 garage, then naturally for against a garage, you will get a garage only. There is a covered parking. Now they say covered car parking in the podium, basement, or stilt area, or a mechanical car parking. You cannot expect something else. Yeah.
Next
I
is
think maybe we can take another 1 or 2 questions max, because I think
Yes.
we kept sir for a long time. So
yes,
Yeah.
yes, sir. One question quick. Can the
Yeah,
joint
there is one,
member
Gurpreet Singh.
Yes, yes,
The
sir.
proposed amendments discussed today does not cover detailed parking rules. Sir, the parking policy has to be prepared by the society. There are a lot of, basement parking, mechanical car parking, there are open car parking, stilt car parking. So there are old under old law, new law, RERA. So therefore, I think that each society need to hire a consultant, understand the intricacies, and then prepare policy which should be circulated among the members, get it approved in the what is called as this one. We will try to cover it in the bylaws if possible. Gurmeet, very good question. I will try to cover in the rules. I'll do that.
There is a question, another by Gurpreet, section 154B11. If 2 flats are owned by A and B, can A vote for 1 flat and B for second flat on an authorization or NOC given by A to B?
No, that is not possible. Because members are A, na? Associate
Owned
member.
by A and B. That's
Correct. See, a flat is owned by A and B. If B wants to vote, only 1 vote will come in 1 flat. So A is not able to vote. That means B is a joint member. With the authority letter from A, B can vote. Yes. But 1 flat is in A and B. Second flat is also in A and B. Then who is the member? First member is A. All voting rights comes from the member. So therefore, for flat 1, he votes A. Flat B, by giving authority to B, B cannot vote. If the
Next
other
question.
flat is in the name of B and A, then B can vote.
Then B can.
some of the over smartness doesn't work.
Yeah. One, I can give a suggestion. They should resign from the membership of 1 flat, or both can resign from the membership, and then they have to, for A flat, A has to apply, for another flat, B has to apply. And then, yes, it is possible. They have to get the transfer done. If they are able to do the transfer done by paying a new, transfer fee of 500 rupees and with an affidavit, then it is possible. We have done that.
Sir, probably
Last
question,
question,
considering
Raj.
the
Yeah.
time. Yes, sir. There is a question. There are conflicting judgments whether to go to cooperative court or high court for redevelopment of cooperative society. But strategically, high court is fast and eliminates various proceedings reaching by way of writ proceedings. Your take on the matter, sir.
So we have to understand the facts. See, whenever any redressal of complaint comes, we have to understand the facts and we have to understand which is the law applicable. I cannot make a overview or one across the board answer to this. Well, the moment you talk about writ has to come against the state. You are talking about against the builder, against the society. They are not the state, so you cannot file a writ. You can file a writ only if it is against the BMC. BMC has done any error. Now comes whether I should go to the city civil court or high court, file a suit, or I should go to the consumer court, I should go to the cooperative court. That is a call a council will have to take. And one has to look at, if it is an individual, I would always recommend that you go to the consumer court. If it is a society, I will also say that go to the high court. See, it all depends against whom and what type of remedy you want to take. Say, suppose if it is an allotment of the flat, wrong allotment, then I would say go to the cooperative court. You want a compensation, then I will say go to the consumer court. So it all depends on the facts and the applicable provisions.
Yes, sir. Over to Apurva, sir. I think we'll proceed for closing, sir. Yep. Yes, sir.
So it's been a wonderful evening, and sir, it's like the rains. You have poured yourself out completely, and so much of information exchange. We are really, really grateful to you, sir. Raj, you'll do the
What
honors.
I suggest, if
Yes,
you
sir.
don't mind,
Sir.
Yes.
Chamber of Tax Consultant and Bombay Chartered Accountants Society, this webinar, lot of questions YouTube has come. If you can capture them, questions have come in the chat box, which I was not able to answer. If you capture them, what we can do is the registered participants, we can compile the question and answer, and we can email them. And if you want, you can publish it in your article magazine as one of the special column, so that people get engaged.
Absolutely, sir.
Yeah.
Yes, sir. Sure, sir.
That is really generous, sir. Thank you.
Yes, sir.
Thank you, Apurva, for arranging this. Aditya Pradhan for giving a short but a nice introduction of mine. And of course, all the president of the Chamber of Tax Consultant, Neha Gada, as well as Kinjal Shah, Bombay Chartered Accountants Society, and all the people, especially Kaushik Javeri, who has been coordinating this. Of course, I don't mind mentioning our team, Vishal Bamne, who has prepared the entire PPT, as well as Sahil, who coordinated from my office. Thank you very much. And all the participants who actually overwhelming response. That is a great thing. Thank you.
So just 1 minute, Raj, formal vote of thanks from you as well, please.
Yes, sir. Sir, thank you very much. As Vice Chairman of the Commercial Allied Laws Committee, it is my absolute privilege to propose formal vote of thanks as we conclude today's highly insightful session, which was attended by over 250 participants, both live on Zoom as well as live streaming on YouTube as well. On behalf of organizing committees and everyone joining in today, I want to express our deepest gratitude to our esteemed speaker, CA Ramesh Prabhuji. Sir, the clarity with which you navigated the topic today was truly exceptional by seemingly breaking down the recent updates across acts, rules, case laws. You delivered session that is immensely practical, not just for practitioners as well as for the cooperative housing society members, the committee members alike. Sir, a successful event like this relies on strong collaboration, and today is a testament to the seamless joint efforts of Chamber of Tax Consultants and Bombay Chartered Accountants Society. I would also like to place on record our sincere thanks to the speaker, CA Ramesh Prabhu sir, and his team members, including Mr. Sahil Murajkar, for coordinating the entire operational aspects. The presidents of Chamber of Tax Consultants, CA Neha Gadaji, President of Bombay Chartered Accountants Society, CA Kinjal Gada, CA Kinjal Shah, the committee chairman, CA Apurva Shah, the the committee chairman from the BCAS, CA Uday Satheji, and the convener CA Aditya Pradhan from the Bombay Chartered Accountants Society, our senior committee member as well, CS Kaushik Javedi ji, for whose efforts made this webinar possible, and also he was instrumental in spreading the word as well. And also we would also like to thank the support teams from both the Chamber of Tax Consultants and Bombay Chartered Accountants Society, who were working behind the scenes and making this webinar possible. Most importantly, a massive thank you to our audience, both here on Zoom platform and also those who have joined us live on YouTube. Your excellent questions and active participations are the livelihood of these professional gatherings. Thank you all once again. Have a wonderful evening and a weekend ahead. And thank you very much. Looking forward to more such sessions. Thank you.
Thank you, sir. Thank you.
Thank you so much, sir.
Yeah.